It's always been the same thing where the pro-government briefs, like the District of Columbia's briefs, how many times can we use the term assault weapon in this brief without actually discussing what we're banning? I mean, that's the ploy. And the court, in that case, and there's been other cases like that, but that was really the first case where we presented evidence that the production of, for example, AR-15 type rifles in the millions since the 1980s, and it's the most popular rifle nationwide, so it meets what the Supreme Court held in the Heller case to be widely protected or and wide use by law-abiding citizens for lawful purposes, and the court agreed with that. But then the court said, well, oh, and by the way, in that case, we also had a lot of expert and lay testimony saying that the purpose of a pistol grip on a gun like the AR-15 is because the way you present it on your shoulder, it's got a straight line design in terms of the barrel, and you have to have a pistol grip that kind of goes down like that in order to aim properly. It's an awkward position if you had to twist your hand up like that. And so we had all the evidence in the record saying that, but it just so happened that there was a Brady Center lobbyist who testified at a DC council hearing saying that the purpose of a pistol grip is to kill as many people as possible while spray firing from the hip. So, and this shows you what courts will do sometimes. The court latched onto that statement and said, oh, this is a good reason to ban this rifle. But do a little exercise with your hand. First of all, if somebody is shooting at you, you'd rather them shoot from the hip instead of aiming at you, by the way. But if you picture a pistol grip on a rifle like that, and then go down like this and see how it feels to your wrist, it's very awkward. But if you have an old-fashioned shoulder stock that just goes like that and put it by your hip, it's a lot more comfortable. So under the guise of that theory, you could ban like the more old-fashioned rifles with no pistol grip or a very slight pistol grip. You could ban those under that theory. But that was enough for the court. And by the way, we had other issues that we litigated in that case, and we just had finality to that case yesterday when the D.C. Circuit, this fall, they had upheld the basic registration system, but we prevailed on 4 issues. Like every 3 years they would cancel your registration and you have to re-register again, and that if you don't re-register, then you're a criminal. You can't register more than one handgun in a 30-day period. And I mean, the police chief laughed at the idea that a gun trafficker would come to the district and register guns before they trafficked them. There was a really weird provision saying that they could make you bring the gun to the municipal police department headquarters. And how would you like to do that? Go to the police station with a gun. And you might, for good reason, you might have some officers who are frightened with things that happen these days. I mean, or you're on the street with this gun case, the SWAT team gets called, and you're a man with a gun in a case, and you know, you might end up dead, or there might be, who knows what could happen. So we got, and then there was a really weird test. We got those 4 things invalidated. And so yesterday, the district's petition for the full court to rehear these issues was denied, and so those are the 4 issues that's the end result of all that litigation. But anyway, in the meantime, as I said, there's other states that have passed these kinds of laws. New York had a law kind of like the federal law that expired. Connecticut enacted such a law. And then after the Sandy Hook elementary school disaster, those 2 states enacted much more stringent laws that banned guns based on the same premises. That we're going to call them assault weapons, and we're going to single out these arbitrary characteristics, and we're going to justify the bans by calling them dangerous and unusual weapons. And so what it's come down to, we had a decision from the U.S. Court of Appeals for the Second Circuit basically saying that in the case of the New York law, for example, you can uphold it based on Second Amendment rights, that these are extraordinarily dangerous guns. And you even have the argument now that, I mean, it used to be a fully automatic firearm. That was the kind of gun that many people would say you can ban, and the Supreme Court said that in the Heller case. But so now the argument has shifted to, well, you know, guns that fire only one shot per trigger pull are more accurate. Because when you fire a fully automatic gun, you have a lot of muzzle rise, and you're not going to hit the target most likely unless you really know what you're doing and it's a pistol caliber or something. But if it's a rifle caliber, the barrel is going to go up like that, and you're going to miss what you're shooting at. I mean, it has a military purpose for a lot of fire, and it intimidates the enemy. But so now they're saying that if it fires only one shot per trigger pull, it's more dangerous than a machine gun would be. And therefore you can ban these rifles with these certain characteristics. And so, you know, these characteristics, once again, are things like, well, the shoulder stock is adjustable, or it's got this pistol grip that nobody likes, or the bayonet stud. So that's what we end up with in some of these court decisions, and that's where that stands. The courts admit that the rifles are widely accepted for lawful purposes. They are the most popular rifles nationwide. The U.S. Court of Appeals for the Fourth Circuit recently rendered a decision questioning the validity of the Maryland ban based on these rules of interpretation, strict scrutiny versus intermediate scrutiny. Strict scrutiny is like free speech. You really look closely at the law. Is there a compelling state interest for a ban? Intermediate scrutiny basically means the government wins if they can think of reasons why they should win. And so the Attorney General of Maryland has quickly filed a petition to rehear that by the full Fourth Circuit. And so we'll see what happens with that case. But in any event, there you have it. There's only a few states that have these laws, and so there's not many court decisions. Most states, politically speaking, there's a lot of support for Second Amendment rights. And it's only the usual suspects. It's California, New York, Connecticut, New Jersey. That's just about it. I mean, Maryland to some extent. And then, so there won't be a lot of court decisions on these cases because they only exist in a few places. Now, let's see how, you know, we're talking about some really irrational things. Let me pose this to you. In New York, for example, if it's got to be a rifle with a conspicuously protruding pistol grip to be banned. It has to have a shoulder stock. That's the definition of a rifle. But if you go to Highland Park, Illinois, it's only banned if it doesn't have a shoulder stock. If it's a rifle without a shoulder stock and it has the pistol grip, then it's banned. If it has the shoulder stock, it's not banned. So it's like the opposites. In New York, it's a horribly dangerous gun if it has a shoulder stock and a pistol grip. And in Highland Park, Illinois, it's not dangerous at all. It's cool. But if it doesn't have a shoulder stock and it has the pistol grip, then it's extraordinarily dangerous. And then if you go to Maryland, they have neither of the above. It's not restricted at all if it has a pistol grip, regardless of whether it has a shoulder stock. So don't tell me something is really dangerous in New York and not Illinois, and then it's really dangerous in Illinois, but not in Maryland. I mean, it's like, who makes this stuff up? And it just shows you how the whole purpose of this is to ban any kind of guns that they can, you know, use this pejorative term about assault weapon, and to, you know, litigate it as if these are really more dangerous or different than other kinds of guns that don't have those features. So that's why my topic title is Assault Weapons or Assault on the Second Amendment. This really is an assault on the Second Amendment. It's banning guns that are very ordinary and very widely owned by people in this country. So I don't want to speculate about what the Supreme Court's going to be like next. I mean, that's another topic. Justice Scalia passed away, And we thought he was going to be there forever. I mean, it doesn't seem right. But the compensation